I will read from the note prepared in the morning, and thereafter, if there are any questions, I'll try to answer the same. In order to avoid lengthy, expensive, stressful, and agonizing litigation, alternate dispute resolution has since long engaged the attention of the civil society. Various modes and techniques has been adopted and followed for dispute resolution from time to time. For example, direct negotiation without the intervention of any third party to settle a dispute in an ideal mode, leaving all the parties happy with the outcome of such amicable settlement. Mediation, consultation, conciliation, and arbitration are some of the modes engaging third-party intervention of appointing neutral persons to bring about settlement of dispute at local levels. All of us must have heard about panchayats in Punjab, Fasilo or Sulh in Sindh, and Jarga system in Khyber Pakhtunkhwa and Balochistan, which are still being considered as powerful institutions in our local system. Though such modes have no specific statutory backing, their verdicts and decisions are used to be accepted and considered as binding. I will now refer to some of the laws, mainly in our province. Firstly, by the Britisher, that was FCR Regulation 1901. If the provisions of that FCRs are gone through, you will find that the decisions on criminal as well as on civil cases are required to be first referred to the Jirga. And that was in fact the mediation or the conciliation at the relevant time. And whatever the Jirga that has decided, that it was then referred to the political agent, and such political agent either has to endorse the same or refer to a second Jirga. In 1961, conciliation court ordinance were promulgated, providing conciliation courts for this purpose. If we look to the provisions of family laws, there are pre-trial and post-trial conciliation proceeding, and the main intention is that the issue, if any, between the parties is decided without the further intervention of the court. Similar provisions were introduced in Industrial Relation Ordinance of 1969, providing for conciliator in the industrial disputes and also a shop steward who was intermediary between the worker and the employer. Addition of ADR provisions were made in the Income Tax Ordinance, Customs Act, Sales Tax Act, Federal Excise Tax Act for encouraging the resolution of disputes. And also insertion of Section 89A in the CPC, and in fact these steps or these legislation that were made by the government. Now I'll refer to a very good law that was promulgated in our province for the area of Malakand division, which was named as provincial administered tribal area in the constitution. And due to certain revolt by the local people against the civil law promulgation, Sharia Nizam-e-Adl regulations were promulgated, and the last in such lands was Sharia Nizam-e-Adl Regulation 2009, which is still enforced in the Malakand division. In the said law, Section 3, I will quote, any civil or criminal case subject to mutual consent of the parties may be referred to Muslih or Muslihin. And different notables and religious scholars were notified as muslih, muslihin, and that list was maintained by different civil courts. For the timeline of 15 days only was given for such decisions. Unfortunately, inclination toward the decision through muslihin has been thwarted, and the ultimate sufferer are the poor litigants. Due to paucity of times, I am thankful. I and our brother judges feel to have been benefited from the opinions of the expert in the conference, and would certainly share these views in our High Court for appropriate rules making and also for the implementation of the ADR laws, inshallah. Thank you for the patient hearing.